Okay, we have Scott on the call and Deb Jyoti. Deb Jyoti is going to be our moderator tonight for the meeting. Mainly, Deb can cover, but because of the COVID-19, there has been a lot of immigration-related issues or questions coming along way on our COVID-19 helpline, and we thought of like setting up this webinar to support community to answer some of those questions pertaining to COVID-19 and immigration side. So without further delay, I would hand over to Deb for the moderate this session. Go ahead, Deb, please.
Thank you so much, Pranesh. Thank you so much, Pranesh, for putting this together, and thanks a lot to the Indian Association of Minnesota. My name is Debjyoti Dwivedi. I am a resident of Eden Prairie and an elected member in the Eden Prairie School Board. I will be your moderator today for the webinar on employment and immigration and the impact of COVID-19, brought to you by Indian Association of Minnesota. Today we have Mr. Scott Borene as our guest, who is an immigration attorney and also a very good friend of mine. Scott is the founder and managing attorney of Borene Law Firm, US and Global Immigration, who was born in Minneapolis. When he was 16 years old, he applied to the Harvard University. He was admitted as a National Merit Scholar. After graduating from Harvard with an AB degree in history, he received his JD degree from William Mitchell Law School in Minnesota. He has more than 35 years of immigration law practice experience. Scott was selected by other lawyers as 2020 Lawyer of the Year in Immigration Law in Minnesota, as noted by the best lawyers in America. He has been repeatedly recognized as one of the top 20 lawyers in the world, most highly regarded by other lawyers in corporate immigration law. He is listed as in the best lawyers in America and acknowledged as an immigration law super lawyer. Scott will provide an overview of current immigration matters during this crisis. This overview will be followed by a moderated question and answer session. Just to set up the ground rules, we already received a lot of questions. So first, after Scott is done with his brief presentation, then we will take the questions directly from where we will take the questions that we have received. Once we are done with these questions, if we still have bandwidth and time, we will invite the questions through the Zoom chat. So without further delay, I will hand it over to Scott. Scott, the floor is yours.
Oh, well, thank you very much. Thank you for the introduction, Debjyoti. Greetings from the very sunny 39th floor of the IDS Center, where I'm sheltering in place, actually working too. And it's a pleasure to speak to your group. There are some materials that I understand, Debjyoti, that after the session is over, you're going to send them to the people that registered that I will be referring to. So when you get those materials, I would encourage you to at least look through them if you want more details about some of the things that I'm going to talk about. So in those documents, I'll just review some of those things. One of the things that is in there is a series of updates. We send out updates to our friends and clients about once a month of the most recent immigration law developments. Most of it is related to employment-based immigration, but not only that, because that's most of what our work has been for the last 30 years. So that's the immigration updates. In the last 4 months worth, I included those. Then there is an article called After F1 What? It's what every student needs to know about H1 work visas, green cards, and other options. It's not just for students. There are multiple documents attached to that. And that is FAQs about H1s, and then an article called Professor Yes, which is originally written for other immigration lawyers to teach them how to handle cases for people with primarily with advanced degrees, but at least a bachelor's degree. And it has a useful checklist. When you look at that, On page 8 of that article, there is a checklist of temporary and permanent, or 7 and 8. There are temporary and permanent option checklists. These include most of the most commonly used work permission options. Not all of them, there are hundreds, but these are the most common ones for people that have at least a 4-year degree. And then there is a handout or a 2-page piece of information about public charge from a nonprofit legal group in California that's pretty good, that explains what is included in public charge and what isn't for immigration purposes. And then there are some additional materials about the L1 category. I was asked to talk about that a little bit, and I will later. And the EB1 category for executives and managers, which is related to the L1. Then I also added, because it's taking so long for people, particularly from India, to get on with their lives, some of them get married in the years that go along. So I included some material about FAQs about marriage and immigration, and also about adjustment of status, whether a person is sponsored by a company or self-sponsored or family-sponsored. That adjustment of status, if they're in the United States, is the most common way that they complete the green card process. So I'm going to go through some news items, but before, and then I'm going to come to some additional slides, decks about some of the things that have already been mentioned as items we'll talk about by Devjyoti. But I'm going to start off with 10 tips. These are 10 practical tips from a person who's been an immigration lawyer for almost 40 years. And based on everything I know about the immigration system and what's different this year with the virus and with the current administration compared to 2016 and the years before, here are 10 things to keep in mind. Tip number 1, if you're in the United States now and you're in a temporary alphabet category, H1, B1, F1, J1, any of the alphabet categories, a temporary status, and you've been carefully following the rules since you last came into the United States, then you'd be considered to be in status or maintaining status. My advice is, do not leave the United States unless you don't care too much about when you come back. You may not get back in when you plan to, and even though you did it and it worked fine, 6 months ago or 2 years ago, or your friend did it, there is a much greater risk that even with a great plan and great documents and great support from your employer, your family, your immigration lawyer, you still have a high risk that you will encounter a significant delay. And when you're outside the United States and you're not a US citizen, you stay outside the United States until the US government says it's okay for you to come in. In some cases, that can be months or years. There are people who are at H1 status from India, even before the virus, that would go back for a renewal of a visa with an approval, and they're working for the same company and the same salary. Nothing had changed. Nothing strange had happened with their own life. And they went back thinking they were just going to drop into the US consulate, just get a new visa, go to their brother's wedding and come back. Some of those people are still there a year or two later. They stay out until the US government says it's okay to come in. The only way that you can reduce the chance of being stuck outside the United States for longer than you want to be, if you're not a US citizen, is not leave. Tip number 2, if you're a lawful permanent resident of the United States, if you've had a green card, that's what a lawful permanent resident means. Green card is a nickname for the document that used to actually be green, but it's not anymore. My advice, this will surprise some of you, my advice is the same. Permanent residents are not considered US citizens, and they can get stuck. And some of them have gone up to Canada for a shopping trip, to visit a relative, or to go to a medical conference, and they have not been able to get back in, even though they had a US passport. Or excuse me, even they had their green card with them and have done it 20 times before, because they're still considered to be a non-citizen. Tip number 3, if you're a US citizen, be careful if you travel internationally. If you're a US citizen and you go to one of the regions of the world that the United States has put quarantine or restrictions on, even US citizens can be not refused entry, but have to go through extra quarantine measures, or you can't get into the United States if you come through one of those countries. We'll talk a little bit more about that later. You could get a delay of 15 to 30 days before you get back in, even if you're a US citizen. Tip number 4, if you're not a US citizen and you're stuck outside the United States, there is much less that even the best immigration lawyers can do to help you get in than if you're here and you're trying to stay here. There are more options, and the more the legal system could work for you if you need it. If you are trying to return, it's not impossible, but it's more difficult. Tip number 5, F's, J's, H's, TN's, E's, and other alphabet categories, B's, should be extra careful to not engage in any activity that might be considered to be a failure to maintain status. That's a legal term under the US immigration laws. Failure to maintain status can render your status invalid and subject you to going to immigration court and being asked to leave the country. Examples of that are somebody staying longer than allowed on their admission document, their status, working without permission. That could include self-employment on a 1099 or get paid cash or something. There are lots of ways to break the rules that many people that aren't immigration experts don't even know are against the rules. Number 6, now more than ever, honesty is the best policy. Abraham Lincoln, the American president, was famous for having said that, but honesty is the best policy, in my opinion, with 40 years of experience dealing with the US immigration agencies, in all communications, spoken or written, that are exchanged with the USCIS, the SEBA system, the consulates, US, the CBP at the land borders and the airports, and even if you're going to get on an airplane and fly from Minneapolis to Chicago, the TSA people that look at your documents before you can get on the airplane, they work for the Department of Homeland Security, and the databases intersect. It's possible that you could have an issue because you're interacting with the government system. So it's very important to only give truthful answers that are the accurate, simple, and polite as of the facts exist on that date. Number 7, each and every person in a temporary category should have a plan. Plan ahead for your next immigration, because temporary doesn't last forever. Plan again for your next immigration steps. I would recommend think 2 years ahead if you can. And what's your plan going to be? What's your plan A? Tip number 7 or number 8, always have an immigration plan B. Sometimes plan A takes too long. The government changes the rules, especially this last year. They've been changing more things that people thought were reliable than I've ever seen. Tip number 8.5, I've added this year, have a plan C as well. Doesn't have to be as detailed, but think ahead, that extra step. What if plan A and plan B both don't work? We are seeing more cases of that. And so have a plan C, and at least an idea about it. Number 9, I recommend, even though we are living in an increasingly digital world, I recommend that you keep hard copies of all the immigration-related documents you have. Obviously, that would include your passport. It also includes copies of your old passports, your I-20s, DS 2019s, H-1 approval notices, EADs, any emails or correspondence to and from the immigration service about anything. Why? Because in the US immigration system, usually the requirement of proving things is for eligibility for a work permission or permission to stay in the United States, or whether you've been following rules, is on you. It's not usually the government's problem to prove that you didn't follow the rules. You have to prove you did follow the rules. Number 10, the US immigration system, again, now more than ever, works best on the following basis. You get written permission in advance from the US government for whatever activity you're going to do in the United States. In past decades, there have been a lot of things the US government was more generous or reasonable or flexible about. Do not rely on getting forgiveness after something has happened. It's not hopeless. It just makes everything much harder. Okay, so now some news, general comment on the whole system. How is it different than it was, I'd say, 3-4 years ago? Everything is slower than it used to be in 2016 and before. The law hasn't changed much. The regulations haven't changed much. Most of the forms haven't changed. So what has changed? Why is everything slower and there's a higher percentage of rejections and requests for more information? What's changed is a series of memoranda, policy changes, executive orders, starting at the very top levels of the US government. And it's taken a while to work its way down to what a lot of people that work with immigration all the time refer to as the culture of slow and the culture of no. There's more of that than ever. So a brief fact. Since 2016, the total number of all kinds of temporary visas, Bs, Fs, Hs, everything, has fallen from 10.3 million per year to 8.7 million per year. For green card visas, immigrant visas, it's fallen from 617,000 to 461,000. The percentage drop is 15% of all types of temporary visas and 25% for all green card type visas. Partly as a result of that, there's this interesting article I wanted to mention from Forbes from a few weeks ago, that there has been a huge increase in the number of people who are born in India, who are in the United States or in India and going directly to Canada. The restrictiveness of the US system in the last couple of years has been paralleled by a more open attitude, particularly for high-skilled people that speak English and are young and have a career in front of them. The number of people from India who became green card holders in Canada increased from 39,000 in 2016 to 80,000 through the first 11 months of 2019. That's more than 100% increase. The denial rates for H-1 petitions by comparison in the United States for continuing employment for the same employer, existing employees, is risen to 12% in the last 3 years. That's 4 times as high as the 2 to 3% rate from 2015. And it varies depending on the type of, in the particular employer. Some have an even higher denial rate. In the first 3 quarters of fiscal year 2019, the denial rate for H-1s for existing continuing employment shot up to 24% from 6%. And the same thing is happening with student visas. Anyway, so a couple other quick highlights of some of the news items of the last 4 months. We had our H-1 lottery. This year was a little different format, but there were 275,000 applications and filed during the March registration period. Only 85,000 could be selected. There were 67.7% of the registrants were from India, 13.2% from China. So that's over 80% from India and China. Those cases are now being adjudicated through the system. We just got our first approval for the one that we filed the first week it became possible this week. Also, of course, the US immigration offices, the local offices, since March 20th, have all been closed for interviews, for personal visits, with very rare exceptions. That is scheduled to end on June 3rd, but it could be extended. And so all of the things that require an in-person interview, such as a green card case, are all going to take longer than they would have before. We'll talk a little bit more about processing times in a moment. Also, the US consulates worldwide have almost completely stopped issuing visas, immigrant visas or temporary alphabet visas, renewals, initial issuances. For people that tried to get in the H-1 lottery this year and failed, there's a mention in one of the update sessions documents I sent out that it says there are many other work visa options, and it's not the only option. Also, most other countries in the world have also adopted restrictions on travel and who can stay and who has to leave, similar to the United States. Not every country is different, and it changes from day to day, week to week. The United States Immigration Service has stopped processing, premium processing, the extra fast 15-day processing for certain things. Those have all been stopped, and they haven't said when they're going to bring them back. They are continuing to process applications for employment authorization, such as a C9 is one category, somebody who's got a pending application for a green card, or an H4 that is eligible for employment authorization, or a J2 or an L2. That is still possible. Even if you've had, if it's a renewal and you've had a previous employment authorization, they will not require new biometrics. They will use the old one in the system and process the application. Okay. The government has a COVID-19 USCIS website. I encourage you to go there. It's got some special features about different things that particularly relate to different parts of the system. L1s I was asked to talk about. The L1 system is pretty much similar to the way it was 2 or 3 years ago, except there's a higher rate of delay and a higher rejection rate and a higher request rate of what I call a maybe response. That's called a request for evidence usually, where they whatever the employer submitted, the government says, whatever you sent us didn't convince us. Do you have something else? And sometimes they give a multi-page list of some of the other things they're looking for. It's particularly difficult in this specialized knowledge category, particularly in the IT services area and some of the companies that are in that area. I think Deloitte was a big one that everybody is maybe familiar with, and they have had like a 40% RFE or denial rate recently. I-140s, the immigrant visa categories, most of those are business as usual, except again, stricter requirements for supporting documents, things like national interest category and extraordinary ability categories are stricter. I would say if anything has gotten a little bit easier, it's probably the labor certification based categories. Next slide, please. Thank you. Yeah, right there. This, I've already talked about the closing of the borders. This is still in effect. No one knows exactly how long it will be changed. There's a list of the countries and regions that if a person comes through them, they have to be outside of that region for 14 days before they can apply for a visa or travel to the United States unless a special exception applied. Thankfully, India is not on that list. China, Iran, the entire Schengen area of Europe, Ireland, and the UK are on that list. So sometimes they have these tricky things where somebody has to figure that they're going to travel to, you know, the Bahamas or something so that they can be there for 14 days after they've been in Europe or the UK, and then they can possibly, you know, apply when the US consulates reopen, or if they have an existing visa, they can try to come to the US. US, Canada, and Mexico borders are shut to all except essential travel. There are different categories that have been marked as essential. I don't have time here to get into the details of that, but for certain things, I think TNs and Ls are considered essential. April 22nd, just about 1 month ago, the president issued a new proclamation that has immigration effects that's designed to protect US jobs for US workers. It prevents the issuance of new green card visas, immigrant visas with some exceptions. It has a provision in it that says, I'm going to read you part of the language, said within 30 days of the effective date of this proclamation, the Secretary of Labor and Homeland Securities, in consultation with the Secretary of State, shall review non-immigrant programs and shall recommend to me other measures appropriate to stimulate the U.S. economy and ensure the prioritization, hiring, and employment of U.S. workers. 4 U.S. senators have sent a letter to Donald Trump about 2 weeks ago, suggesting that when he comes out with that new rule, if he follows that advice with that report, these senators, including Senator Grassley, who's a very senior senator from Iowa, he said, this is what's in their letter. After 60 days, we urge you to continue to suspend new non-immigrant guest workers for 1 year or until the national unemployment figures return to normal levels. Some people are saying that it's going to be 2 or 3 years, maybe 5 years before it returns to the pre-virus levels, whichever comes first. That suspension should at a minimum include H-1 visas and the optional practical training program foreign student visas extension after graduation. So that's what might be coming soon. All right, we'll move on then. Next slide, please. Agency and department closures. We already talked about USCIS offices being closed. There's some of those relief measures are mentioned there, extra time to respond if you get an RFE or that maybe thing. And that premium processing is still suspended. The CBP, Customs and Border Patrol, the people that work at the airports and the land borders, if a person is here from a country that has the 90-day provision, such as somebody from the UK that comes on 90 days without the need for a visa, but they can't leave because they can't get out of the United States or they have some other reason where they can't leave and they're going to have to violate the 90-day rule, in order to not disqualify themselves from future visas, they will consider giving a 30 days of satisfactory departure, but you have to contact the government and ask for it. All the State Department, all the consulates and embassies are continuing to be closed. This Department of Labor is kind of doing business as usual. Not much there. Next slide, please. Some other major changes that have gone into effect. The big one is the public charge rule because of a Supreme Court decision that went into effect nationwide. And they're asking now for anybody that gets a green card, whether you're applying inside the United States or from outside the United States, the government's asking a lot more questions and added some long new forms that weren't in place before. Credit reports and lots of other details. It's not the way it was prior to February. It's stricter. The public charge rule, I had mentioned there's the trap with the COVID-19. Some social agencies are saying, oh, if you need this, we'll give it to you. It's medical benefits. It's okay with the state of Minnesota. Some of those things are not okay. It could be a public charge issue if you took advantage of it. So my recommendation there is be careful. And so some things, it does not, public charge doesn't affect people applying for citizenship or renewals of green cards. But it can apply anybody who's applying for a green card or a person who has received public benefits that are what are called means tested. That would not be unemployment insurance. It would be Medicaid and poverty assistance and things like that. Next slide, please. Okay. F1, STEM OPT, H1B, furlough, and early termination issues. A lot of companies have had drastic cutbacks in their revenues, and they've had to lay off people that 6 months ago or a year ago, they had no plan whatsoever to lay them off or terminate them or furlough them. So basic quick review is F1 STEM OPT people, if they get terminated or furloughed, the business has 5 business days that they have to, before they have to notify the CVIS person at the university. The student has 10 days to report. The F1 STEM OPT person during their 2 years of STEM OPT that's approved can only get up to 150 days of cumulative unemployed time without risking damage to their status. F1 OPT, the regular 1-year OPT after a bachelor's or master's or whatever degree, that's 90 days cumulative unemployment. In some cases, it is possible to volunteer in some of these things, but volunteer doesn't mean work doing your same job that you were getting paid for and then just agree to work for free. That somebody has to check out the details of that before they proceed with that. H1s. There are very few exceptions, but an H1 needs to be paid the full H1 salary that they were getting. And even if everybody in the company gets a 20% reduction, they can't just cut the H1 salary by 20%. Usually the employer will have to file with new filing fees and legal expenses a new H1 to amend the prior H1 to switch it to part-time or to get a new wage assessment. There also are issues about telecommuting that are fact-specific and case-specific. So let's go. Next slide, please. Okay, so these are a couple of things that Deb Jyoti had asked me to look about. We already talked about the USCIS interviews and biometrics. The consulate's closed. The Department of Labor, this is one little bit of tiny good news. The Department of Labor is processing labor certifications in about 4 months. We just got an approval, a couple of approvals within the last few days for cases that were filed with the Department of Labor after the recruitment test in December. We've temporary visas. I'm going to tell you a little bit about processing times. The citizenship interviews and oath ceremonies prior to the shutdown were taking about 9 to 12 months for your citizenship interview and about 4 to 6 weeks for oath ceremonies. Once they start interviewing again, I expect it'll be many months more than that delay because of the big backlog that's built up. Processing times, according to the government, for I-129s, H-1s at California Service Center are typically 3 to 4 months. L-1s about the same. Nebraska Service Center processing times, they shift some of the H-1s around, and some are at Nebraska, and they're 3 to 4 months. I-140s, the immigrant visa, this is the document to, after you've gotten an approved labor cert or your employer has, you apply it in the EB1, 2, 3 category. Those are taking about 6 to 8 months at the Nebraska Service Center. And green card interviews for employment-based cases are taking, depending on where you are in the country, if it's in basically the Nebraska Service Center area, they're estimating it's probably 9 to 14 months. If you're in the California Service Center jurisdiction, it can be 9 to almost 3 years. Okay, next slide, please. Okay, so about unemployment benefits, I'll have a little detail thing here on that to tell you, and also about the stimulus checks. We'll do the money parts first. And we already talked a little bit about the furloughs. So does a stimulus check or an unemployment check, does that make a person out of status, or does it raise a public charge issue? It's not completely clear because this is all very new, but the stimulus checks, it's unclear whether accepting a stimulus check is considered a public benefit for a green card or non-immigrant visa application. Technically, it's a tax credit paid in advance, and technically doesn't fall under income maintenance like other kinds of welfare. But it's a gray area. I am not a tax lawyer. I'm not a labor and employment lawyer. I'm not a CPA. And so I can't give you specific advice about that or about the unemployment benefits I'll talk about in a minute. But I think you should be careful about that. If you want to be really cautious, don't spend it if they've sent it to you, or you could, some people, if you can afford it, you want to avoid the risk altogether, or you sent this to me, I'm not sure I'm entitled to it, and try sending it back. But I'm not recommending any specific advice or action that you do that or not do that. Everything is fact specific, and you need to know more details and probably consult an appropriate expert, which is not an immigration lawyer, except on the public charge part. Unemployment benefits, generally, historically, unemployment benefits are not considered to be welfare or the type of public assistance that is like the other types of food stamps and so forth, or government housing. So I'd say probably that's safer, but that's a state law thing, because unemployment benefits in general are state law determined, and somebody who has an H-1 to work for a particular employer at a particular job, if they're available to go back to work and the employer doesn't terminate, well, I guess if they do terminate them, that's a state law question, but they have to be available for work. And available for work, if you have only essentially a license for a work permit to work for a particular employer at a particular location, a particular job, there's some question about whether you're actually entitled to that under the state laws. So that's how that goes. In general, though, there are very few exceptions for a person's an H-1, and the employer is the one that gets into trouble probably more than the individual if the employer tries to cut back or not pay the H-1 employee for a time when they're actually working as an H-1. There's some good information available from, if somebody wants to send me an email or give my office a call, from the National Immigration Law Center that has a very nice I think it's about 15 or 20 page detailed thing on COVID-19 relief bills and the effects on immigration. Okay, then I'm going to wrap up here with a couple of other items before we go to Q&A. Legislation. Currently, I follow legislation pretty closely. It's partly very important to my clients and to me. I make my living based on complying, helping people comply with US complicated immigration laws and helping people to follow the rules so that they don't have problems that are avoidable. So this year, there are several pending immigration laws. One of the ones is a holdover from last year and several years prior that's of particular interest to many in the Indian community in the United States, and that's the Fairness for High-Skilled Immigrants Act. That kind of has stalled since last summer. At this point, in spite of some back and forth with some amendments on the Senate, I don't think it's likely to have any legislative action this year because almost nothing that isn't directly related to the virus and the economy salvaging is going to even get voted on in Congress. There are only 50 days left out of the 170 days between now and the election where the Congress is even going to be meeting their legislative days, and that they're not going to change that in an election year. And that calendar is pretty full. Maybe there's a slight chance, maybe 10%, that something might happen after the election, what's called a lame duck session. But more likely, it will be at least a year before there's any significant immigration law change, no matter who the president is. Okay, then I want to just extend an offer. A lot of people will have individual questions that are fact-specific, confidential, and if you want to get a second opinion or you don't have an immigration lawyer and it's more detailed or personal that you don't want to discuss it in this kind of forum, which often many people would like to have a more private conversation. Normally we charge for a consultation that lasts an hour to an hour and a half and it costs a couple $100. But for anybody who is a member of the India Association, given the circumstances we're in, I will offer to do a personal, at no charge to anyone, free mini consultation for 15 minutes by telephone on any immigration related question. All you have to do is call our office and say that you would like to have a mini, M-I-N-I, and you heard Scott speak to the India Association. And he said that if I called and asked for a mini about an immigration question, you would schedule a time for me to talk with him at no charge. At the end of that time, if it's something that's really complicated, we want to see a lot of documents, we would probably give you the opportunity to schedule a full appointment for a full consultation. That usually takes an hour to an hour and a half, and there is a charge for that. So with that, that's everything that I had to say for things before we go to the question and answer. Hello? Good.
Hey, Deb, if you are speaking, you are on mute.
Sorry, yeah, I was talking and I was on mute, my bad. Okay, so we can go ahead with the Q&A. If I already have the question. So first question, Scott, is from a O1 visa holder whose visa is valid till 2021.
Mm-hmm.
He was furloughed and now he is laid off.
Mm-hmm.
So he's wondering if he doesn't get any job opportunities, what are the options in front of him?
Okay.
Like basically, whether he can file a self-petition and if there is a requirement for that, and all those things. And he just so you know him, he's in a hospitality industry. He's a culinary chef. So
okay. That's just interesting. One of the very first green card cases I did was for an executive chef in a restaurant that I got an O1 visa for. That was like 35 years ago. Actually, it wasn't. Couldn't be about 30 years ago because that law's only been around for 30 years. You mentioned that the visa was valid until October 2021. There's an important legal difference between a visa, which is the stamp and the passport, and a status, which is the your legal permission to be in the United States. You can have a valid visa and be out of status, and you could have a problem. If you're in status and you're following the O1 rules and the US Immigration Service has granted you O1 status, it doesn't matter if your visa has expired. Visas are just good for going to airports, really, or going to borders and trying to get a status. The final decision of what your legal status in the United States is not based on the visa, it's based on the admission decision at the land border or the airport. And then if the person has not maintained their status, they could lose their status and be at risk of going to immigration court. So in this particular kind of circumstance, the company asked the person to go on furlough. That means different things to different people. For many people, it's that you don't need to come to work. We don't want to end the employer-employee relationship. We think it's just going to be temporary. We'll see. And if it's the hospitality industry, maybe people were thinking they could go back to sort of normal, March 23rd to May 10th, and then laid off. Now, is laid off in a business setting, often laid off still isn't a termination. It's, we're not going to call you back until we need you, and we don't know when that'll be. It'll be indefinite. So all those things are important legal differences. It's going to be fact-driven. I can't give him or any of the callers specific advice to do or not do something because I haven't done a full in-depth review of all the facts and all the important documents. However, are there other opportunities for someone in the situation where they were in status following the rules O1 and they're in a business of they have high culinary skills, and if otherwise they wouldn't be an O1. If some other O1 employer is interested in sponsoring them, then that other employer could do it. Self-sponsorship by an individual for O1 isn't really possible. The only way that could happen is you'd have to set up a separate corporation, which is complex and expensive and meet a bunch of extra documentation and financial rules and so forth. And even then, that's tricky. Then he would be an employee of his corporation that he may be a part owner of. But in the permanent category of EB1 extraordinary ability, which overlaps a little bit with the requirements, you can self-sponsor there, but this probability of being approved for that is much more difficult than to get an O1. So I would say that person should definitely either have a consultation appointment with an immigration lawyer. If they don't already have a personal immigration lawyer, they should find one because the clock is ticking, and the longer you wait before you decide what the next step is, it could put you in a weaker position. But there will be options. There are multiple options that could allow that person and their family to stay in the United States, and there are multiple options that could be a basis for employment authorization. Next question.
Wonderful. Thank you so much, Scott. So the next one is from one of our members who asked, like, one of his parents, I think both of his parents are green card holder, and they visit USA every year.
Mm-hmm.
Now, the parents are currently in India right now, and he's wondering if he can file an extension due to this situation. Can he file an extension from USA? What is the procedure and what is the timeline?
Okay. A person who has lawful permanent residence in the United States who leaves without a clear plan or a clear ability to come back within a reasonable period of time. It's actually, the rule is based on their intentions. If they want to come back, but they can't because they can't get a flight on Air India to get them out of India because of their issues with that, that may be a partial factor in saying, oh, you didn't abandon your permanent residence. The burden of proving that you've maintained your permanent residence, which isn't really permanent, it's fragile. You can lose permanent residence by being gone too long or getting involved with law enforcement or tax things. One thing that sometimes comes up is people have green cards. Nobody ever explained to them that as a green card holder, you have to report and pay worldwide taxes on your worldwide income, even though the property is located in India or Singapore or something else, or you have offshore bank accounts. You have to report those every year. If you haven't done that, those folks may have to do some amended late filed US tax returns for every year since they got a green card. And assuming they have that taken care of and there isn't any other obstacle, then they could apply for a reentry permit, but it is impossible to apply for a reentry permit unless you are physically in the United States at the time. We strongly recommend that anybody with a green card these days that's traveling anywhere should probably, as a precaution, it's like having a flu shot. It doesn't guarantee you won't get the flu, but it makes it probably a lot less bad. You don't have to wait for months for the adjudication, but you have to be physically present in the United States on the date that the I-131 reentry permit application is filed. So I would recommend that this person's father and mother get back into the United States as quickly as they can. They don't need to get a visa. They can just apply as green card holders, and hopefully they will be allowed to come back into the United States. And as soon as they come back in, they should file for a reentry permit. There's a fee involved. The form is pretty simple. The approval rates, if the facts are good, can be over 90%. They don't have to stay here and wait for the decision. The validity period of a reentry permit is 2 years. So the flu shot could work and give them not 100%, but the best possible protection of their permanent residence. If that doesn't work or they get stuck out longer than that, then there is something called a special immigrant visa that somebody who has had a green card and has lost it for one reason or another might be able to get issued by a U.S. consulate abroad. But that's all very fact specific. So that's the procedure and the timeline. The reentry permit is Form I-131. And the procedure, you file it from inside the United States. The person filing it, not the son that's trying to help out, but or the daughter. It's the person who is the green card holder who has to be physically present in the United States on the day that the reentry permit is applied. Otherwise, it's invalid.
Wonderful. So just a clarification for all the audience. As I can see all the questions, what I did is I put together same or similar questions and asked to Scott so that we don't go over the same questions over and over again if there are repetitions. Just a FYI.
Okay. Now the one footnote I'd make to that is if I had access to all of the facts and was able to ask all of the questions, I would ask someone that was concerned about that. The general information I'm giving might not apply to them. There are exceptions to almost all the rules. But consolidating them is very efficient and a good idea. So what is the next question, please?
Sure, Scott. So the next question is, so if somebody is going through hardship right now for this virus, and if they incur any public charge, how will that impact the future green card filing?
Okay, well, there's one of the, they should absolutely consult with, if they have not already accepted the financial help, they should consult with an immigration lawyer before they decide whether to accept it or not. Because if you don't take the assistance, then it probably has no effect in terms of public charge, just because somebody offered it to you. However, if the person has used something that is considered by the government, the immigration service at a later time, at a temporary visa application or a green card interview, and they consider that to be a problem, that person should not leave the United States until they have completed the entire green card process, including, you know, fighting it out in court if they have to, if they want to stay here. Because go back to my top 10 tips. If they leave the United States and try to do stuff from outside, they stay outside the United States until it's completely resolved, which could be months or years. And there's less that a lawyer can do to help them, less than they can do to help themselves. If they resolve it while they're here, even though it might be burdensome, they have a better chance of success usually if they stay here and try to persuade the government to be generous. There is no automatic forgiveness because of COVID-19 from public charge. And it's all about the devil of the details.
Wonderful. Thank you so much, Scott. The next question is, somebody who is trying to transfer H1 to a new company on the expiry of the current one, is it expected for that employee to be in the payroll of the new company immediately, or does it give him or her 60 days grace period before one get out of status?
Okay, whether it's an expiration of the H1 time for employer number one, or the person gets a call from a headhunter, they heard about a job that pays more money and it's in a nicer community and they want to do it because it's an opportunity. If they're changing employers, the new employer has to file a completely new H1. If they have been counted against the H1 lottery quota already, they don't have to repeat that process. So they are more hireable by any employer in the United States because they've been counted against the quota. Normally, a person can only have a maximum of a total of 6 years of H1 time before they have to leave the United States and be outside for 1 year, and then they can get recounted against the quota. Good luck. And then get another 6-year period. In some cases, if a person has made enough progress through an employer-sponsored green card application before the end of the 5th year of H1 time, they can get extra time for 7th, 8th, 9th. There are people here that are 15th, 20th year H1s from India because the green card backlog in the immigrant quotas are so bad. So the basic rule for somebody in status is H1 that still has some of their 6 years of basic eligibility time available. The new employer should file for them as soon as possible. The employer can choose the start date of the H1 petition. If the person's trying to stay in the United States and not fall out of status, they should request a start date. The new employer number 2 should request a start date, I would say no later than 59 days after the last day the person was working for employer number 1, and can prove it with pay stubs or a letter from the employer that says you're terminated or you resigned and this is your last day of work. And so finding that new employer is the critical step, and persuading that new employer to file the H1. Hopefully they do a good job with it. And then as long as it's filed with the government before that 60-day period runs out, then the person who is working can stay in the United States until there's a final decision on that. They can even, in some cases, go to work for the new employer under a special rule called H1 portability, but it's only temporary. The person, if the employer doesn't want to do that, the person who's being sponsored for the second employer can stay here while they wait for the decision. Once the new H1 is approved, the employee has to go to work basically almost immediately if it's after the start date. So if the 60-day period for this person is going to start on June 1st, then by the end of July, the new employer has to have filed the new H1 petition and requested a start date of, say, July 30th. And if that gets approved on, as some of these H's are, within 5 or 6 weeks now, on July 15th, then that employee should go to work for him and the employer should start paying him. There's a little bit of fudge room there of maybe a few days, but not weeks and months. So that should be the case. It should be remembered that H1s can be part-time or full-time, temporary or permanent positions. So one of the ways that the employer that's concerned about, well, can I afford to have this person full-time? I'd rather delay it a little bit. Build it, you can design it and build it carefully so it's elastic. So it says part-time, at least 10 hours per week at such and such hourly rate, 10 hours or more, that's possible. So they could go up even toward full-time, but they have to build that in at the beginning. If you put in an H1 as full-time, then the employer cannot cut their hours or cut their pay without having to refile a new petition. But if you plan ahead and design it as an elastic, flexible, part-time, up to 40 hours or more, then you may be able to do that and have that flexibility. But the latest that the person could go on the payroll would be the date of approval of the H1 petition or the date specified for the start date, which can't be more than 60 days after the prior employment.
Wonderful. Thank you so much, Scott. So moving on to the next question. So if the parents are here on a visitor's visa, which is B1 or B2, and they are post 6 months because of the current situation with the flight not, not being available. So can they extend the stay? And if they can extend the stay, do they need a biometric because the biometric centers are closed? So how does it work? How will it work?
For any application that requires a biometric, the government is still accepting the applications. Usually you apply first and then the government sends you a biometric appointment notice, but they're not sending any. And the ones they sent out in prior to March 20th, they canceled them all. And they said, we will send you a new notice when we're reopening. A person who is in a B, and I would suggest if they email or call our office. I didn't include it in the materials I gave to you in advance for this session, Debjyoti, but we have some FAQs about change of status or extension of stay for Bs and about the B category in overall. And I'd be happy to send that at no charge to anybody if they just request it. But the basic rules for a B is the person has to have temporary intentions at all times they're in the United States. They need to have a plan for a specific date that they are going to leave. A lot of times it's a good idea to include a copy of a return air ticket back to their home country. If you want to, if the inexpensive ones are the ones that are non-refundable. The ones that are refundable, and so you could change the date if circumstances change. They usually cost a lot more money, but that's between the person and the airline. But the government, we find, is more likely to say yes if they can see the person has a definite plan and they've actually bought a ticket or at least made a reservation for a particular flight within the period allowed. Usually people don't ask for more than 6 months. It's not against the rules to ask for, I think, up to a year on a B extension, but the chances that it would not be approved for the 1 year are pretty good, pretty high, that it won't get the full 1 year. The default setting for the government is usually 6 months on a B extension. And that I would not say that somebody should put in a B extension and the only reason they're asking for it is, oh, things are not very good back in my home country right now, and I'm not sure I'll be able to work there, and it's a little dangerous. I just want to stick around longer. That's a weak application. It's possible it could be approved, but it's not a very good one. If you're just trying to wait out the virus, I would say you probably should have at least 1 or 2 other good reasons why you're staying here. Sometimes people are here and their parents, and they have a grandchild here, and maybe the parents need some help at home, but they don't want to make it sound like the parents are unpaid nannies. That's another trap potentially. So you have to be a little careful, but it all is very fact specific, but it's not impossible. You want to apply before the current B status expires. And it says, I think, hypothetically, let's say the 6 months ends on July 30th. I would recommend that they start planning the documents and planning the filing no later than the middle of June, probably send it in by the beginning of July with 3 or 4 weeks to spare. And then it's common that these will take 3 to 4 months or longer before they're even looked at. The government will cash the check, send a receipt, and it will just sit there in the processing queue. During that time, the person's allowed to stay in the United States awaiting a decision. They're not allowed to work. Bs are almost never permitted to do any kind of work. They can't go to school full-time either.
Wonderful. Okay, moving on to the next question, Scott.
Mm-hmm.
Does the virus have any impact on EAD renewal, which is C09? The individual's I-140 is approved. They have a priority date, which I'm not saying. They have a green card interview completed in March. They came in the US in July of 2010 on the L1, and AOS was filed in the EB1 category.
Okay, well, I haven't seen the documents, but it sounds like from those last facts you mentioned that, and there are different subparts of EB1, but I'm assuming since the person was an L1A, they're in the EB1 transferred multinational executive or manager category. That's what some people call the EB1-3 or the EB1C, and it has similar eligibility criteria as the L1A. And the fact that the person was interviewed but still doesn't have a green card is probably because they're in a retrogressed green card category that's gone backwards in time. So the cutoff date, the visa bulletin, which is published every month by the State Department, and it's a publicly available document, it's not a secret, and it has cutoff dates that they list for people. If you have a priority date, and the priority date is really important. Let's say the priority date is in January of 2018. Right now, the May visa bulletin says for India in EB1 category, people who have a priority date that's on or before August 1st of 2015 are now eligible for final action. That hypothetical person is now 3 years into the future before there's a current date. They cannot give a person a green card unless this priority date is current in that month's visa bulletin. It's possible that this will stay backlogged for years before it gets back there again. There are multiple factors in determining how these dates move. But as far as getting their EAD renewal, there's still, it sounds like, a pending green card applicant, which is a lot better than being an L1 because there are time limits on L1s. Even as an L1A, it's a maximum of 7 years. But as a pending green card applicant, if you're caught in the backlog, you normally can keep renewing your employment authorization for yourself. And if you have family members, they can keep renewing theirs. And generally, the only thing about the virus that's different and how those green card or those work visa EAD renewals is there's actually a little benefit because they waive the biometrics requirement if you've had a previous EAD, which from the fact pattern that you described, the person had an EAD previously. So they're getting a renewal or extension of that EAD. And so they would be eligible for that little tiny COVID benefit that says, oh, you can't, we closed the biometric centers, but we'll just use the old biometric information and we'll process it anyway. We've actually had people in that situation that have gotten their C9 EADs just fine within, I think 3 or 4 months. So I'm hopeful for that one.
Wonderful. Okay, so the next question is somebody who's on EB2, and their dates are not moving. So his or her question is India getting any spillovers because he is seeing his date not being moved? He's seeing the date not moved from May 2009 for last 3 years. Now, I know, Scott, you already went over that. Yeah. If you want to just quickly touch a line, because I know you went over all those things.
Okay, well, this is a mystery. Every month, every immigration lawyer in the country, eagerly awaits the next month's visa bulletin. There are certain times of the year that there tend to be big jumps. And that usually is at the beginning of the federal government's fiscal year because that determines the quota total numbers per year. The government's fiscal year starts on October 1st. So often when you get to July, August, September, they want to use all the possible visas they can before then, and then they become unavailable because they don't want to waste them. So they use them up several months before then. So you'll see the dates creep forward, and so it'll look like everything's going to be fine, and you can file for it. But if you don't cross the finish line with the final interview and approval before midnight on September 30th, that's it. Or if it retrogresses, then you still have a pending application. But if it does come current for 1 month, which October is a popular month when they jump the cutoff date in a favorable way, often because it's a new year and they want to get a whole bunch of people in. You should go through the door while it's open and not wait for 2 or 3 months because it's inconvenient. The door can close and the dates can go backwards, sometimes by years, and stay there. There are some forecasts with the numbers of how many people from India are waiting in line for EB2 and EB3 that have forecasts running out that 20, 30 years, and some really dismal forecasts if they don't change the law at all. I think at some point they probably will change the law because it's unacceptable. They just have to get a political majority to do it. They come close a couple of times, but it hasn't happened. But some of them are 50 to 100 years, which is absurd. Yeah. But in the meantime, if a person's a pending green card applicant, then they have most of the freedoms that of employment and economic activity. It's just fragile. It's just a year at a time or 2 years at a time, an EAD at a time. This is not helpful for people who have children that were maybe in elementary school when they started the green card process, and now it's 12 years later and they have children going to university. Well, if they're going to university, they can't get US government financial aid or student loans because they're not permanent residents. And sometimes that is a motivation to try to get into a higher category, EB1 possibly, or something like that. And it is very sad that this happens. And I expect that there will be some major changes in the next few years, not the next few months, to make it more even. It's absurd that you have India and China, which account for more than half of all the human beings on the planet at the moment, and yet the combined quota for India plus China for all the different types of quota-based green cards is the same as the quota for Switzerland and Luxembourg. It's absurd. But it doesn't make any common sense. It doesn't make any fairness sense. It doesn't make any economic sense. It's not in the best interest of the United States. The only kind of sense it makes, this is where being an American history major in university helps out. It makes political sense. There was a political majority to pass laws that put the laws that are currently still in effect at the time. And you have to get a new political majority to do something about it. I think eventually it will, the political pressure to do that will be irresistible because the United States, the native-born US people, there aren't enough of them. We would have a shrinking population, and the ones that are born here are less likely to get advanced degrees and higher education and making the economy grow even faster. So just like there are, even right now, this is the horrible time to talk about worker shortages with 20% unemployment, but I think that is a very temporary thing, particularly at the high school skilled area. I've heard from somebody who's an expert in unemployment law just this past week. Prior to the virus, the unemployment rate for software engineers in the United States was about 3%. After the virus, it dropped to 2.5%. So that's the economic reality. And companies like whether it's Google or colleges or universities have trouble, they're exempt from the H-1 quota, but they're not exempt from the green card quotas. Eventually, I think there will be some relief, and hopefully it isn't a Band-Aid that just keeps being renewed every year. But for now, that person might have a wait of some time. They should just keep on with what they're doing until there's some relief.
Okay, wonderful, Scott. Thank you so much for actually letting people know like why the per country cap is a problem for people who are stuck in the green card backlog for like 50 to 100 years, and why the per country cap need to go so that it's become a first come first serve process, and when they can get their green card before people who are yet to born and yet to come in the United States. So thank you so much, Scott, for highlighting.
Welcome.
Next question is from an individual whose H-1B is expiring in July. They have submitted I-140 in April, but they haven't got the receipt yet. So they're wondering, he or she is wondering, do you have any idea when USCIS open premium processing? And if he doesn't get his I-140 approval, extension receipt, and India flights on or before his max out date, then what should he do? What are the options in front of him?
Well, there are lots of options. I need more facts. If the person is, their H1, their current H1 status is due to expire at say July 31st, and they have no more H1 time available. If their I-140 was based on a labor certification application that was filed by the sponsoring employer before the end of that H1 person's 5th year of H1, they would be eligible for added time or overtime H indefinitely, as long as that permanent application keeps pending in the system. So that's how you can get people that are 10 or 20-year H's. And that's not even as good as being a pending green card applicant, because it's not unrestricted employment authorization for that person, and their family members don't get any work authorization, with the exception of H-4 employment authorization while it lasts, which is, it's in danger of being canceled at any month. But assuming that that I-140, assuming that there was a labor certification filed before the end of the 5th year, the fact that there's a pending I-140 and it's taking a long time isn't any disadvantage. Most of the labor certification-based H-1 or I-140s are in fact being approved. Usually they have over a 90% success rate. When it eventually does get approved, the priority date is not based on the I-140 approval date or the I-140 filing date in April. It's based on the filing date of the labor certification, which is usually several months prior to the submission date of the I-140, because it usually takes 4 to 6 months to complete a labor certification through the process before you can then file the I-140 with an approved labor certification from the Department of Labor. So if the person's in the most favorable set of facts, it's not really a big problem. The only thing is then the question about the premium processing and why didn't he get a receipt? The reason that the premium processing is suspended is because the government did this last year with the H-1 lottery. They canceled the premium processing for all the H-1s for the whole system, not just the lottery cases, because they felt that they would have to refund the money because they couldn't process them all, because the great majority of the H-1 lottery cases request premium processing. And so this year they canceled it for everybody, and it's still in effect for all types of I-129s, even, you know, I think religious workers, all kinds of things, TN extensions. So I think my guess, and I don't have any inside information about this recently, but I think at some point they will bring the premium processing back around the same time as they did last year, which I think was sometime in early summer, but they didn't bring it back for the lottery cases. They brought it back for some I-140s and for the other non-lottery temporary worker cases. So I would say there's a possibility that maybe premium processing will be back for I-140s by midsummer or the end of the summer. Not a guarantee. There are a lot of people that think because the government's USCIS doesn't get funded by taxes, it gets funded by revenues, and they make a lot of money, frankly, on the premium processing. If you do the math, you say 1,000 premium processing cases is more than $1 million, and they've got hundreds of thousands waiting. They'd like to use the money. So I think that might tempt them to bring back premium processing sooner rather than later, but can't tell. The no receipt is the government made an announcement about that. And normally there's a law that says if government takes money, they have to issue a receipt, I think within 72 hours or something. But they're ignoring that right now because of the virus. Eventually you'll get the receipt if the person paid by check and the government cashed the check and they filed their I-140 as we usually do with a courier that's reliable, such as FedEx, and you got proof of delivery. If something goes astray and you can prove you sent everything in, you have complete hard copies of everything, and you can prove the delivery with the FedEx and prove that the government cashed the check. We've had cases that you can, even though the government can't find the case, they will accept it as filed by that date because you have better proof than they do.
Wonderful. So the next question comes from an individual who has an approved I-140 of September 18.
Yep.
Kid will be aging out, I mean, more than 21 in January 2021. Now, they haven't got a chance to file for 85 as the date is retrogressed.
Yeah.
So he or she is wondering if there's a way to protect the kid on their green card when they go beyond 21.
That is an exotic question. I'm sorry, I don't know the answer. A lot of these things I can just know from off the top of my head, but that was one I haven't researched lately, and it is something that does require research a little bit. but I would say it probably will turn out, even after you do the checking, that the kids are on their own because there was no adjustment of status application file because it never got current enough, or they missed the date with the couple of months that it might have been open. So the children are on their own. So what is the children's, what is the parent status right now? Do we know?
They have they have an approved I-140 on September 2018. So I'm guessing they are on H1.
In status H, probably. There may be a 10th year H or something. Or...
No, sorry, they are on L1. I figured it out. They're on
L1. Okay. Well, then the children would be L2s probably, but they don't have to be L2s. They might, especially if they're approaching college age, they can be F1s. And if they are inside the United States and they have an in status L1 parent, but they're adults too after they're 18 years old, they can apply for an F1 and apply to change status to F1, and they have a pretty good chance of getting that approved. And then they also would get permission for on-campus employment. They won't get student loans because of the approved I-140. Not government ones. If they are very, very good students and can get into some of the more elite, very big endowment universities, Stanford, Harvard, Princeton, Duke, and places like that, even McAllister here in Minnesota, they have hundreds of millions of dollars of endowment because they've been very fortunate. And they provide full scholarships to some international F1 students if they can show need and they meet the admission requirements. So I would say the first thing I would think about in that situation is to evaluate whether the children could be switched to F1. And let's say the parents are stuck in this permanent long thing and they even finished college and they want to go to medical school. Well, then they should work really hard when they're in school, because getting into medical school, we do a lot of work with physicians and clinics, Mayo Clinic, university hospitals, and things like that. And the U.S., if you want to get a medical education in the United States, get a USMD, rather than a UK or India MBBS, and you want to have a medical career, then it's very difficult to get into a U.S. medical school like the University of Minnesota if you're not a U.S. citizen or permanent resident or a political asylee, because they vigorously and legally discriminate against people that aren't U.S. residents and taxpayers, because they get a lot of their money from the state legislatures. So if that student, though, is a very, very good student, and they can manage to get into Harvard Medical School or Duke Medical School, they could still, go there and get some kind of financial aid potentially. But so the advice, for the students is the same advice you give to everybody, I guess, is do the best work you possibly can, because it gives you more choices as you get older. Right?
Cool. Okay, sorry, I was muted and talking.
Okay.
Okay, so the next question that we have is, I know we are very close to the time, 9 minutes, so I'll try to go as much as I can.
Okay.
So somebody who has an I-94 date, which is based on the passport expiration date, which is in October 2020.
Yeah.
And if all the international travel is banned till then, how can he renew that passport? The I-94 date.
Okay. Sometimes that is an error made by the U.S. government, the CBP people or the Immigration Service. They mistakenly will put a visa expiration date that matches the passport expiration, even though the underlying, say, H-1 petition is valid for a longer time. Now, if the H-1 petition, the reason the I-94 date happens to coincide with the passport date is also because that's when the H-1 petition expires. Well, that person, as long as they should renew their passport, first of all. Everybody should always have a passport that's valid for 6 months past the date that they're physically in the United States. Some consulates are a little slow. That's another reason you should probably try to renew your passport even when it's 9 months or 12 months before expiration, in case there's a delay or a consular shutdown by your home country government. But passports can expire, but the visas in them are not expiring just because the passport expires. So somebody who could have a 3-year validity H-1 visa in that passport that's expiring on October 20th, and they got that 3-year validity H-1 visa based on a 3-year validity employer's approved petition that is valid from January of 2020 until January of 2023. The passport can expire, but the visa is still valid. They need to get a new passport and combine the new passport plus the old passport with the still valid visa in it, and then they will have a perfectly valid visa. But again, it's the passport expiration can affect the status eligibility because you have to have that valid for 6 months past the time you're here. And what matters more is the I-94 and the person's status in the United States. If the visa can expire or it can't be renewed by departing the United States because the person can't get out or can't get back or the consulate's closed, but they can still continue their status or even switch to a different status inside the United States as long as they apply for it in time and they have proper documents and proper facts, and they could, all the rules about changing status. Anybody in any alphabet status, with the exception of some J's, can apply to switch to another status without leaving the country, without their passport leaving the country, without ever going to a consulate. So I would look at that person, the status is the key thing. I'd want to see all their documents and ask them a whole bunch of questions to make sure they weren't working without permission or anything like that. And if it turns out that they were, then there'd be some good options for them to extend that. Get the new passport right away. Don't wait to talk to a lawyer. Get that underway right away. And then start looking at what are my options to extend my legal stay, my legal status beyond the expiration date. Sometimes the petition's already valid and it was a government error. The I-94 mistakenly lists the passport expiration date, which is wrong. That's a government error. But getting the government to fix the mistake that they made isn't the easiest thing, but it's not impossible.
Wonderful. So I'm skipping the next question from somebody who asked the same question, kind of H1 valid till 2022 and the passport expiring 2021, because that is answered in this question.
Okay.
Moving on to the next question, somebody who has a H1B with an approved I-140 till 2022, can he join the new company on the receipt notice? And if they want to come back to the old company, if they didn't withdraw the petition, is it possible?
Okay, let's get some dates here. So this is a person who is in H1 status now for employer number one.
Employer number one.
When does that expire?
2022.
Okay, to 2022. Okay, and then now he wants to switch and go to employer number two. And do another H1able job. And the employer number one has already filed an I-140 petition on this person's behalf. Was it based on a labor certification or one of the other I-140 categories? Do you know? You want to guess?
It just says, I will read the question for you.
Mm-hmm.
It says, I have a valid H1B visa with approved I-140 till 2022.
Okay, those are two separate things that got a little jumbled there. I-140s aren't approved until 2022. It's the H1 that's valid until 2022.
Right.
And there's an approved I-140. What's the priority date of the I-140 is useful information, but not essential. Now, I assume that it was employer number one that filed the I-140 to sponsor this person.
Yes.
Okay, and then assuming that in order for a labor certification based I-140 to not die, it will die at any point from the date that the labor certification was submitted up until the day the person actually gets their green card, if either of the following two things happens. If either the employer or the employee gives up their intention to work in that permanent job when the green card eventually arrives. If either of them breaks the chain of continuity of continuing willingness to take the permanent job as described in the labor certification and the I-140, and the employer says, well, for 6 months, we're going to cancel it, but we might revive it. You can't. You break it, it's dead. there you may be able to save the priority date, but that labor certification is broken because you broke the continuity. You make it a divorce between the divorce between the employer and employees' permanent intentions for that specific job. So you could use the approved I-140 possibly to get extra time eligibility for additional overtime H-1 to work for employer number 2. And if employer number 1 is agreeable to the person switching to work for employer number 2, because, well, business is really slow, it's going to be really tough for us here. If you want to go work somewhere else, we still love your work and we're happy to have you back, and we're going to save some money to employ you when you finally get your green card. But it's possible to have more than one H-1 in effect at the same time. And remember, they can be part-time or full-time. So you could layer on a part-time flexible H-1 with employer number 2. He could also maybe on the next round of H-1 extension or an amended one for employer number 1, he could have 2 H-1 employers at the same time, both of them part-time to full-time. And as long as he's working for at least one of the H-1 employers, he is in status. He doesn't have to work for both. And it gives him a little extra insurance policy, but this is very potentially complex situation, but it has some potentially interesting and good solutions that would benefit the individual and the employers.
Okay, so another individual asks, is it a good time to look for opportunities in other companies when you have I-140 approved and waiting for a green card with your existing employer?
The big risk there is an employer went to considerable expense and effort to get that I-140 approval and that labor certification. By law, the employer had to pay 100% of the legal expenses and the advertising expenses for the I-140. They've been paying all the H-1 expenses all the way along. And if this person leaves and then goes to work, worst case, for a competitor, if you were the employer, would you be happy about that? And you have the employer controls the validity of the labor certification. The employer controls the continued validity of the I-140. They can change their mind. They can withdraw it. They can send a letter to the government and say, we changed our mind. Oh, by the way, the reason we changed our mind is the person that we sponsored went to work for somebody else, and we decided since they weren't going to stick around and work for us, we didn't care enough about them, so we're just going to cancel the whole thing. So the person might be able to salvage the priority date. In some circumstances, there's something called AC-21 permanent portability, which could allow the person, if the job, the new, I actually invented an acronym when this law came out, same or similar occupational classification, SOSOC. I called it SOSOC, and some people in the government picked that up. So the new job has to be similar enough that it qualifies, and there isn't any clear definition. But if it's close, it's probably worth a try. And that way they then could use the I-140 and the labor certification approval from employer number 1 to actually get a green card through employer number 2. But that is tricky. That is not a do-it-yourself project. They absolutely should have a very experienced immigration lawyer help them with that, but it's not impossible.
Okay, I know we are at 8, but I will ask this last question and then I will let Pranesh give any other options if he thinks. So what advice do you have for folks who are stuck in the military naturalization backlog, and how long does it take to issue interview notice after the status shows that USCIS will email the notice shortly?
Did you say military naturalization?
Yes, military naturalization. So basically people who were in MAVNI.
Yeah, okay, yep. Okay, well, MAVNI, it's sad, but that is basically, it's at least in suspense, and a lot of people are trying to fight to bring it back. I happen to know the people that created that category. Margaret Stock was a former West Point officer, and she invented MAVNI. She won the MacArthur Genius Award for doing that, actually. But and anybody that asks me I don't know the answer to the question, but I know who does know the answer, if anybody in the country does. And her name is Margaret Stock, and she lives in Alaska. She has an office in Alaska, and she also has one, I think, in Seattle. But it's Stock, spelled S-T-O-C-K, and her first name is Margaret. And I would suggest this person or anybody with a Mavni question, go to Margaret Stock. If she charges a consultation fee, pay it. She is the absolute guru on Mavni and anything related to military naturalization.
Wonderful. So we are at 8:03. I know we passed our time. Prinesh, what instructions you have for us?
So I think we have many more questions in a pipeline right now. So what we try to do, we are going to try to take those offline and try to get those answered by Scott and publish it on a website. Mm-hmm. So folks who ask those questions, they can get those answers from our website.
Mm-hmm. Okay.
Is that okay with you, Scott?
Actually, I have a little bit of a problem with that. I'm much more comfortable if you set up another time and just did oral questions. Written questions, we have to be very careful what we say, and is the person a client? If the person wants to ask the question, I'll give them mini, but lawyers have to be very careful. And you put all these qualifications, if this, and that takes a lot of time, and I'm a slow typer. So I would say I would rather give somebody 15 minutes of free, personal, confidential time on the telephone, or in another session of this. If you want to do it sometime, I'm available. I mentioned that to Deb Jyoti, especially during these difficult times. If some of the groups that I work with are the higher education, all the colleges and universities that have international students in Minnesota. For decades, I have been coming to give immigration updates to them, and they have, I think, 6 or 7 meetings a year, and I go and give those in person. The last one was a Zoom one like this one, but I would be happy to have that kind of a relationship with the India Association, either on a, just another one sort of like this one, or just questions and answers with no presentation, whatever works best for you. And that would be my preference, rather than giving written answers to written questions. It just is, it takes too much away from client casework time, and I have to be too much more careful about what I say.
Very, very well said, and makes sense. We'll try to work offline and see what best approach, whether to pass on the information or schedule another one.
Okay.
So I think in interest of time already, we are past 5 minutes. I would like Kiran Bandi, our Vice President from India Association of Minnesota, speak few words.
Yep. Hi, Scott. Thanks for taking time out of your schedule and helping everybody in our community. We really appreciate, and it was very valuable thoughts that you shared and valuable information that you shared. And we will plan for a follow-up, or we will share the information that you shared about your free consultation for 15 minutes with our community. And I want to say, I can't thank you enough for the information that you shared. It was very valuable. Thank you so much for your time.
You're very welcome. I'm very pleased to do it. Namaste.
Thanks a lot, Scott, and namaste. Thanks a lot, everyone. We are going to conclude this webinar here, and we will publish this recorded session online, and we will try to get the follow-up action as suggested by Scott, and get that follow-up going. Thanks a lot.
Thanks, everyone. Thanks,
Thank
Scott.
you very much, Scott, and thank you very much, Prinesh and Indian Association of Minnesota. Thank you.
Thank you, everyone.
Yeah, thank you, everyone.